Imagine this. You're 70 years old. You've lived in the same house for 32 years. You know every creak in the floorboards. Every stain on the carpet has a story. Your mortgage is paid off. Your name is on the deed. You've worked your whole life for this. Then one morning, you wake up and you can't move the left side of your body. A stroke! You're rushed to the hospital. You survive, but you can't speak. You can't write. You can't make decisions. Your daughter arrives at the bank the next day to pay your water bill before they shut off service. She shows them your ID. She explains what happened, and the teller says, "I'm sorry. Without a power of attorney, we can't help you. She can't pay your bills. She can't access your accounts. She can't hire someone to mow your lawn or fix your broken furnace. She can't do anything. Everything is locked, and the consequences start immediately." This isn't fiction. According to the Consumer Financial Protection Bureau, this scenario plays out every single day across the country because 5 basic legal documents were never put in place. Not because people were irresponsible, not because they didn't care, because they didn't know. Today, we're going to walk through the 5 most important documents every homeowner over 60 must file before it's too late. Every fact you're about to hear comes from official government sources: the Consumer Financial Protection Bureau, Medicare.gov, the IRS, the Social Security Administration, and verified research from trusted aging policy organizations. And stay until the end, because there's a massive tax trap hidden in document number 5, one that could cost your children hundreds of thousands of dollars in capital gains taxes if you make the wrong decision about your home. Most people have no idea it exists, but you're about to. Let's get started. The story of Linda. Let me tell you about Linda. Linda was 71, a retired librarian in Michigan. She owned her home outright. No mortgage, no debt. She had 2 sons, Tom and Brian. Linda told both of them, over and over, "When I'm gone, you two split everything. The house, the savings, everything. 50-50. Tom and Brian agreed. But Linda never wrote it down. She never signed a will. She never filed a power of attorney. She never set up a transfer on death deed. She figured her word was enough. Then one afternoon, Linda collapsed in her kitchen. Massive stroke. She survived, but she couldn't speak, couldn't write, couldn't make any decisions. Tom went to the bank to pay Linda's property taxes. They turned him away. He called Social Security to redirect her benefits for her care. They said he had no authority. He tried to arrange home health aides. He couldn't sign the contracts. Tom had no choice. He hired a lawyer and filed for guardianship. It took 9 months. During that time, Linda's house sat empty. The lawn overgrew, pipes froze, a lien was filed for unpaid taxes. Tom spent over $11,000 in legal fees just to get the authority to help his own mother. Meanwhile, Brian, feeling excluded from the process, hired his own attorney and contested the guardianship. The family fractured. All of it could have been avoided if Linda had filed 5 documents. Document number 1, Durable Financial Power of Attorney. This is the single most important legal document for any homeowner over 60. A durable financial power of attorney, POA, gives someone you trust, called your agent, the legal authority to make financial decisions on your behalf if you become incapacitated. This includes paying your mortgage or property taxes, managing bank accounts and investments, selling or refinancing your home, handling insurance claims. The word durable is critical. According to the Consumer Financial Protection Bureau, a regular power of attorney stops working the moment you lose capacity. A durable POA remains in effect even after you can't make decisions. Here's the trap most people fall into. They assume their spouse or adult child can automatically step in. They can't. The CFPB is very clear. Without a valid, durable POA, no one, not your spouse, not your children, has legal authority to manage your finances. The only option your family has is to petition a court for guardianship or conservatorship. The CFPB calls this process lengthy, expensive, and very public. It can lead to family disputes, competing petitions, and court-appointed strangers making decisions about your life. Here's an update you need to know. The Social Security Administration now offers advanced designation of representative payee. This allows you to name up to 3 people who can manage your Social Security benefits if you become unable to. You can set this up right now through your My Social Security account at ssa.gov. It's free, it takes minutes, and it could prevent months of legal chaos. Do it today. Document number 2, last will and testament with specific home provisions. Let's talk about your will. Not just any will, one that clearly states what happens to your home when you die. According to the Consumer Financial Protection Bureau's Guide for Older Americans, a will is the legal document that outlines your wishes for your property after death. Here's the dangerous misconception. Many people think that telling their family what they want is enough. It's not. Without a valid written will, your home is distributed according to your state's intestacy laws, meaning the state decides who gets it, not you, and the state's formula may send your home to people you never intended. Legal assistance organizations warn that without a will, families face unnecessary time and expense navigating probate courts. It can also create tangled titles, where the person living in the home isn't the legal owner and can't sell, refinance, or even properly insure it. The cost? Probate without a will can take over a year and cost more than 3% of the estate's value. On a $350,000 estate, that's over $10,000 wasted. If you're over 60 and own a home, you need a will. And if you already have one, check the date. If it was written before a divorce, remarriage, or birth of a grandchild, it may need updating. Free legal help is available through the Elder Care Locator at 1-800-677-1116. Document number 3, transfer on death deed or revocable living trust. This document is a game changer, and most people have never heard of it. A transfer on death deed, TOD deed, lets your home pass directly to the person you name without going through probate. No court, no delays, no legal fees. According to the CFPB, it's simpler and less expensive than a trust. As of 2026, about 30 states plus DC and the U.S. Virgin Islands allow TOD deeds. You file it with your local recorder of deeds. You keep full control of your home while alive. You can change or revoke it anytime. If your state doesn't allow TOD deeds, use a revocable living trust instead. A living trust lets you transfer your home into a trust you control. You're the trustee. When you die or become incapacitated, a successor trustee steps in without probate. But here's the critical mistake. People set up a trust and think they're done. They're not. The CFPB is explicit. A trust is ineffective until property is transferred into it. You must retitle your home in the trust's name. Skip this, and your home still goes through probate. Also, beware of unsolicited trust offers. The CFPB warns these are sometimes scams. Always verify credentials and consult an independent attorney. One more key point. Medicaid.gov states that state Medicaid programs are required by law to seek recovery from estates of people 55 plus for nursing home care. States can place liens on your home during your lifetime if you're institutionalized, but they cannot recover if you're survived by a spouse, a child under 21, a blind or disabled child. Know these rules before making transfer decisions. Document number 4, Advance Healthcare Directive. This protects your body, not just your finances. Medicare.gov explains that an advance healthcare directive has 2 parts. Part 1, a healthcare proxy, durable POA for healthcare, naming someone to make medical decisions if you can't. Part 2, a living will, stating what treatments you want or don't want if your life is at risk. This includes resuscitation breathing machines, dialysis, tube feeding, organ donation. Here's a common mistake. People think their financial POA covers healthcare. It doesn't. The CFPB is clear. You need separate documents for finances and healthcare. Another error, creating the directive but never telling anyone where it is. If no one knows it exists during an emergency, it's worthless. Give copies to your doctor, your hospital, your healthcare proxy, trusted family members. Good news. Medicare covers advanced care planning at no cost during your annual wellness visit. Bring it up at your next appointment. Medicare.gov confirms you have the right to document your wishes without discrimination. Lack of a healthcare directive is a leading cause of conservatorship cases. Don't let it happen to you. Document number 5, Homestead Exemption, Senior Property Tax Exemption. This is the document that saves you money every year and contains the hidden tax trap. Most states offer homestead exemptions or senior property tax exemptions that reduce your home's taxable value, lowering your bill. Some states offer tax freeze programs capping annual increases. But here's the problem. These are not automatic. You must file an application with your county assessor, and often you must renew it annually or every few years. Experts warn anyone can forget, especially seniors who receive lots of mail. Miss the deadline and you pay full price. Over 10-20 years, that's tens of thousands of dollars lost. On the federal side, the IRS offers Form 1040 SR, a senior-friendly return with larger print. Starting in 2025, there's a new enhanced deduction for taxpayers 65 plus. According to IRS publication 554, if you sell your home, you may exclude up to $250,000 in capital gains, $500,000 for married couples, if it was your primary residence for at least 2 of the last 5 years. Source: IRS publication 523, The Hidden Tax Trap. Here's the tax trap that can destroy your family's wealth. If you gift your home to your child while alive, they inherit your cost basis. Example, you bought your home 40 years ago for $70,000. It's now worth $450,000. If you gift it, your child's basis is $70,000. When they sell for $450,000, they owe capital gains tax on $380,000. At 15%, that's $57,000. At 20%, it's $76,000, plus state taxes. But if you keep it and they inherit after death, the basis steps up to $450,000 under IRS Section 1014. They sell for $450,000 and owe zero tax. That one decision, gift versus inheritance, can mean tens of thousands of dollars. Source: IRS publication 551. Talk to a tax pro before transferring your home. 3 steps. This week. Step 1. Checklist list. These 5 documents. Circle what you're missing. Durable financial POA will with home provisions. TOD deed or trust advance healthcare directive. Homestead tax exemption call 1-800-677-1116 for free help. Step 2. Distribute copies. Give your POA to your bank. Give your healthcare directive to your doctor, hospital, proxy, and family. Set up advanced designation at ssa.gov. Step 3. Annual review all 5 documents once a year. Update as needed. Closing what you just learned can protect your home and your family, but only if you act. Share this with someone over 60 who owns a home. These documents only work if filed before the crisis. Thank you for watching. Stay safe, stay informed, and protect what matters.